remains unclear how many of the detainees released because of the High Court immigration decision could be brought back into custody. That's under new laws proposed by the federal government. Let's go live to Sky News political reporter Joel Philp. Joel, the opposition says that very few of these convicted criminals could be redetained.
Tom, look, to be redetained under these laws, a person needs to have committed a serious crime or a crime of sexual nature, either violent or sexual nature, and have been sentenced to either a life in prison or at least a maximum sentence of 7 years. The question then becomes how many of this cohort of about 145 people fill that category. I've been told the vast majority of them have committed crimes seriously enough that they could fall under the scope of this legislation. What happens next, though, is the minister gets to determine whether he proceeds through the court to try to have these people pulled out of the community for the sake of our broader safety, and then is the court that ultimately determines what the best approach is. It could be detention, it could be some other form of suppressing of their rights, for example, stricter visa conditions than they are currently under. The opposition believes that there could be very few people that are actually pulled into the ultimate powers of this new legislation, perhaps only a couple.
The regime that the government's providing might have application to 2 or 3 or 4 people. That's it. So the other 142 that they've unnecessarily released into the community now have the potential to cause harm, and I think the Australian public are rightly very angry about it.
I will be honest, I can't tell you where Mr Dutton plucked that figure from. It sounds like a figure that he has created simply to come up with another excuse to oppose. It's what he's been doing all year.
The government has made it clear that from its perspective, the releasing of these people was not optional, that the High Court had ordered they needed to be released because they faced no possibility of being deported into the future. Now, if this legislation becomes law, what would occur in the case of preventative detention is that there are effectively 3-year rolling periods, 3-year rolling orders, which can be renewed by a court. And of course, the legislation is expected will be introduced, these amendments to the upper house on Wednesday, which gives the government just 48 hours or so to get it passed back through the lower house after that. So certainly tight timing within the current parliamentary schedule before the end of the year. Tom?
Joel, thank you.